So we move on to the third legal basis of information processing as laid down by GDPR, the legal obligation. In this video, we are going to talk about the legal obligation parameters that GDPR defines and allows as a legitimate way to process anyone's personal information. Welcome to my YouTube channel where you daily watch new content on data privacy, and as I mentioned, today we are going to talk about the legal obligation, the third basis of lawful processing of information as per GDPR. What are these? Under what circumstances is a processor and a controller allowed to do this processing? The definition, it's required by the law. So if in case you have someone's personal information available with you and there is a legal need to process it, then you don't need to wait for the consent. You can process that information. The only thing that is very important is that the legal need must be a part of either the European Union law or the member state law to which that citizen belongs to. Right? You don't need a consent, you don't need to wait for it. The only things, two very important things. One, there has to be a logical legal reason for it, and second, there has to be a transparency with data subjects. Right? Data subject should be informed, clear, and one of those ways, as always, is putting it up even in your privacy notices. Right? You put it up in your privacy notice and say that if you find any legal need to process your information, we will process it without waiting for your consent. You have to have a proper legal reason for it. What are the few use cases or examples of legal obligation? Employment laws. You have a set of people working with you and suddenly there is a workplace safety issue. So looking into employment laws, you are allowed to process personal information if it helps you ensure safety in the workplace, or if there is a requirement to share tax information of any of your employees with the regulators, then also you are allowed to share the personal information. Financial regulations, the anti-money laundering laws and the KYC, know your customer documents, can also be processed without waiting for any consent. Their processing is also considered legal. Then there could be public health issues. Public health issues could be normal minor diseases, they could be contagious disease spreading around in the area. So in that case, you might end up with the necessity of informing people that XYZ person in your area is infected and therefore you need to be careful about it, right? So you process the personal information of that particular individual. And finally, corporate governance, audit and financial disclosures. So while managing your organization, if there are corporate laws that say that you have to perform audits, there could be financial disclosures required, then again you don't need to wait for any consent or don't even need to go and ask for a consent before processing the personal information of the data subject. How would an organization ensure that they are compliant with the legal obligation basis of lawful processing? First, very important in almost every aspect, proper documentation. If you have proper logical documentation, you can always justify. Decision could go wrong, but no documentation or decision is for sure wrong. Data minimization. You are going to process only the information that is required. If the authorities need you to tell them the salary and say gross salary and net salary of an employee, that's what you need to tell them. You don't need to share the banking details of that employee if the authorities don't want to. So you will process minimum information. The same example applies to purpose limitation also, that the purpose is only to share the salary values, so you're not sharing the bank account details. You need to provide information to data subjects, and as I mentioned earlier, you can inform them generally, or you can even put it in your privacy notices that if in case required, you will use their personal information. You should be available always to answer any request that comes in from data subject with respect to his personal information, and you should honor his personal data subject rights. If your data subject wants to use any of the rights with respect to the GDPR rights provided for a user, then you should be honoring those rights and say that yes, this is your information, this is how we are handling. It could be right to object or right to or correction, rectification. So you need to be prepared for all that. And finally, what is your data retention strategy? Everyone should be aware of what is your data retention strategy. For how long are you retaining it after processing, and how are you retaining it? The standards of CIA triad also apply irrespective of the which lawful basis of the GDPR are you using to process any personal information. So legal obligation under the lawful basis of processing personal information. That's about it. I hope you like my content. Please press the like and bell icon. Share your feedback in the comment section and subscribe to my channel if you have not already done that. Thank you.